This video discusses an element of civil code known as agency law. The purpose of this tutorial is to supply and introduce the viewer to laws that may affect their business as a travel agent and does not intend to offer legal advice. As in all legal matters, the person to turn to for advice is your legal professional. The authors and speaker of this video tutorial are not legal professionals. So let's start by asking a few simple questions. What is a travel agent? The most common term for someone who sells travel is a travel agent. But legally, what does that mean? The term agent means that you are acting on behalf of someone else, known as a principal. A principal that an agent represents may be a supplier, a client, or another third party. An agent may represent a supplier, a client, or another third party, two of the three, or all three of the same. What is an agency and how is it established? Here is a definition of agency from Black's Law Dictionary. A relationship created either by express or implied contract or by law, whereby one party, called the principal or constituent, delegates the transaction of some lawful businesses or the authority to do certain acts for him or in relation to his rights or property, with more or less discretionary power to another person, called the agent, attorney, proxy, or delegate, who undertakes to manage the affair and render him an account thereof. What is agency law? It is the law regarding a principal and an agent. The law defines establishment and responsibilities of principal and agent. The law also defines element of control between principal and agent, and it provides for the duties and termination of agency. Finally, the law defines legal responsibility of principals and agent. What is fiduciary? The most common is a trustee of a trust, but fiduciaries can include business advisors, attorneys, guardians, administrators of estates, real estate agents, bankers, stockbrokers, title companies, or anyone else who undertakes to assist someone who places complete confidence and trust in that person or company. A fiduciary is held to a standard of conduct and trust far above that of a stranger or of a casual business person, is the highest possible standard of care in business. A fiduciary must avoid self-dealing or conflicts of interest in which the potential benefit to the fiduciary is in conflict with what is best for the person who trusts him or her or it. For example, a stockbroker must consider the best investment for client and not buy or sell on the basis of what brings him or her the highest commission. Whose agent is a travel agent? Before the Airline Deregulation Act of 1981, travel agents were appointed by the Air Traffic Conference, who executed an agency sales agreement with travel agents that defined a travel agent's duties and obligations to the ATC's members carriers. The agreement imposed a fiduciary obligation upon the appointed travel agents. Today, the Airline Reporting Corporation, ARC, continues appointing travel agents and executing the agency reporting agreement on behalf of its member airlines, imposing a fiduciary responsibility upon its appointed travel agents. Travel agents must adhere to the standards as set forth in agreement and are held liable for any deviation of the standards. As an example, a travel agent that sells a client a hidden city fare to save the client money will be charged the difference between the fare and the fare they should have sold. The agent breached their fiduciary obligation to the airline and will have to pay the debit memo. Travel agents act as agents for the supplier, who is the principal in the transaction. So what about the client? Remember that definition of an agent is a relationship created either by express or implied contract. Let's say that the name of an agent's agency is Your Travel Agent. A new client visits the agency and asks, "Are you my travel agent?" And the agent responds, "Yes, I am your travel agent." In this case, it would seem that the agent is implying that they are entering into an agent-principal relationship with that client. The client would have every reason to believe the agent has a fiduciary responsibility to them. Here are the differences in your relationship with the client. As an agent of the supplier, you only have to be fair and honest with the client. You can't cheat or grossly misrepresent information to the client. It is very difficult for a client to bring a lawsuit successfully when your agency relationship as an agent of the supplier has been disclosed. As an agent for the client, you are held to a much higher standard of care for the client's arrangements. If something goes wrong, you either knew of it or should have known about it, the client can sue using a claim of breach of fiduciary and be awarded substantial damages. Here is how to use the agency disclosure notices. Always have your clients sign it in writing. Introduce it at the beginning of a conversation. Have your attorney prepare it for you, as each state's agency laws are different. You can find samples of agency disclosure agreements in the Forms and Documents group at travelprofessionalcommunity.com. So let's recap the most important points. Agency relationships may be created by implication. Travel agents are generally agents for the supplier. Agency disclosure notices should be in writing and signed by every client. We hope that this video tutorial has helped you understand the need for agency disclosure notices. If you've enjoyed this video, why not give it a like and subscribe to our channel to be notified when future video tutorials are released? And have a great day.